Hi friends, this is Prem. Last week Thursday, Supreme Court has given the very important decision about the green card holders deportation. It arises a lot of question about the CBP officers authorities and whether they can deport any green card holders. Because earlier the green card holders means like there is no issue on the port of entry. They can enter like a USA citizen. But the government itself many times mentioned that green card is nothing but the immigration visa. On top of it, now the Supreme Court also given the decision regarding the deportation of the green card holders. There are so many queries around that. Today we are going to discuss all our questions to our attorney Henry. He is from Manifest Law Firm, and Manifest Law Firm is given a free consultation for your visa or any green card queries. You have QR code on your screen, just scan it and use it. Hi Henry, welcome to the show again. So today we are going to discuss about the very important topic. Last week Supreme Court has given verdict regarding the green card holders deportation. We have so many questions because a lot of people are asking so many questions regarding this news. Before going to the video, எப்படி இருக்கீங்க?
நல்லா இருக்கீங்க.
Yeah, I'm good, Henry. So, can you just explain about what is the Supreme Court verdict regarding the green card holders deportation?
This is a very technical decision, so I'll try to explain as simply as I can. But for a long time, the law basically said that if you are a foreigner coming into the United States, then every time you are at the border in the airport, let's say, you are asking for permission to enter. Or you are applying for admission to the United States. But there was an exception saying that when you are a green card holder, if you already became a permanent resident, then a green card holder has more rights and they are not really asking for admission. They are just coming back home, right? So it's a little bit of a difference in the law on what that means. And this case is about somebody who had a pending charge, but not yet a conviction in a U.S. court. And they were coming back to the United States, and instead of the officer letting them in as a green card holder, they only allowed them in on a parole. And they said, no, you have this charge. I don't know if you're allowed to come in. We're not going to let you in LPR or green card holder status. We're only going to parole you in a temporary status. And then for several years, he was fighting this, waiting for the criminal charge issues to be resolved, and then fighting it with DHS about the deportation. Finally, it went all the way up to the Supreme Court, and the Supreme Court said that CBP was correct. The difference there is basically just that if you are coming in applying for admission, you have much fewer rights, and it is a lot easier to deport you, right? So when somebody is coming in and trying to apply for admission to the United States, then there is a law that has a list of grounds of inadmissibility. That's basically a long list of things that says if you've done any of these things that you are inadmissible, meaning that you're not allowed to come into the United States. That list is much more strict than another list in the Immigration and Nationality Act that is called grounds of deportability. So normally, a green card holder who is inside the United States doesn't have to worry about the inadmissibility. They only have to worry about the deportability. So, for example, one of the differences is that if you are a green card holder and you have some kind of a charge against you, then usually that does not make you deportable under the law. It only might make you deportable if there is an actual conviction, and if that conviction is an aggravated felony or some of the convictions that are counted as crimes involving moral turpitude. So these are very technical terms that the deportation attorneys use, but it basically means that your criminal record has to be pretty serious, something really serious before it actually gives the government the authority to get rid of somebody who already has a green card. Because the principle is that you've invested a lot of time, you've gone through the vetting process, and you've made it to green card status, and this is your home. So the reasons for getting rid of you, sending you outside of the United States, should be something that is a higher standard, right? But now, with the inadmissibility under this Supreme Court ruling, it becomes easier to basically get rid of green card holders because for inadmissibility purposes, you don't even have to have a conviction. You can just have a charge against you, like an arrest record. And if you admit to an officer that you did something, even if there's no conviction in the record, they can use that admission against you and basically say that you are now inadmissible and you're not allowed to come to the United States. So I think the biggest difference there is just going to be for people who have some kind of a criminal record or arrest record. It does not mean that everybody is going to be in danger of, not being allowed back into the United States. But it does mean that if you have any issues at all, more than a parking ticket, right? Like if you have been arrested at a protest, or if you had some domestic disturbance that, police were called because maybe you were arguing with your spouse or something like that, even if you think it's a small thing and it doesn't matter, you should probably talk to an attorney before you travel internationally, even if you have a green card, because this ruling does make it easier for the government to get rid of you if you are coming in from outside. If you're already inside the US right now, it doesn't make it easier for the government to deport you. But if you are leaving and coming back in, they can do the same thing like they did with this person who was part of that Supreme Court case. They can say, okay, we'll let you in on a parole, but not as a green card holder, and then we will do the deportation process faster, and the burden is on you to prove that you didn't do anything wrong. But if you are a green card holder who is already legally in the U.S. in green card status, then the burden is on the government if they want to get you deported. So it's basically, if you are here legally as a green card holder, it's a lot more difficult for the government to get rid of you. And if you travel, that's one way they can now use that against you, and it might be difficult for you to get back in if you have any of this kind of criminal issues.
Wow, you just clearly explained, Henry. So earlier the green card means the people will think most of the times while they entered at the port of entry, they think like, okay, it's nothing. So it's always granted. But now it is not the cases. So case by case is differs. What I meant to say. So they have to check their records very carefully, right? So in case if they have any accident history, so on the road, so does it impact anything at the port of entry for them?
Probably not. Traffic issues generally are not serious enough, but they can get more serious, right? So, for example, I've seen cases where somebody has a driving under the influence conviction, and if it's just one time, depends on the state, of course, because it's a state law, so some state laws are different, and it might be a very serious issue, but in most states, that one single driving under the influence conviction would not make you inadmissible to the United States. But there are different laws where if you do it repeatedly, then the punishment gets higher and it basically becomes a more serious issue. So if there's some kind of driving under the influence issue, for example, I would definitely say talk to an attorney and have them analyze that. But if it's just an accident where maybe you were at fault, but not criminally at fault, right? Like maybe your insurance has to pay for the damages of the other person's car, but as long as it was not a reckless driving with, you're hurting people because you drive drunk or something like that, then I don't think that's going to be a big issue. So if you have a fender bender in the parking lot, you just bump into somebody's car and have a little dent, I think you don't have to worry that you're going to get deported, right? But if it's something bigger and more serious, then absolutely talk to a lawyer first.
Yeah, it totally makes sense. So it sounds like the CBP officer is having all the records, whether it's a criminal records and all the charging records, and as well as the any driving records and whatever things, everything is on their system, right?
It does seem to me that they've been building some kind of automations and integrations with different systems over the years, because many people have told me like, oh, hey, I have this conviction from 20 years ago, but I've been traveling so many times and I'm not worried at all. They never do anything. And then all of a sudden, one time they come in and they get pulled into the secondary inspection because now CBP notices it in the system, right? So the systems are constantly getting upgraded, and maybe previously there was a state database that they didn't have access to, but now today maybe they do have access to it. So you should not rely on the idea that, oh, it's an old case and therefore maybe nobody knows about it, right? Because every state is constantly doing upgrades, they are digitizing their records, and they are creating integrations with the FBI and things like that. So it's very possible that even if something happened long time ago, today it might be in the system for the CBP officer to see when you come in. Or one more recommendation I would have for people is that if you've had a green card for a long time already, check your eligibility for naturalization. Because once you become a U.S. citizen, it is almost impossible for anybody to kick you out of the country because you're a citizen and you have much more rights. So there's millions of people in the United States that have green cards who are actually eligible to become citizens if they want to, but you have to apply. It's possible that you have an old conviction or an old charge that no longer prevents you from getting citizenship. So it might make travel more complicated now, but you might actually be able to apply for citizenship. So I'll give you an example. I live in Arizona. I helped somebody who's a teacher for one of my children that they had an old charge in their record for a driving issue. And they were very, very scared that they're going to lose their green card. But I actually figured out that they were eligible to apply for citizenship. And we did the application. So they were scheduled for an interview. We did the interview at USCIS. They passed their civics and English test. They were scheduled for an oath ceremony, and they got their certificate of naturalization. So they became a U.S. citizen, and now they never have to worry about that conviction again, because whatever conviction they had in the past, the government cannot remove a U.S. citizen from the United States because of that. And also, they are now eligible to sponsor more of their family members for green cards if they wish, because, for example, a green card holder cannot sponsor for parents, but a U.S. citizen can sponsor their parents from abroad to get green cards in the U.S. So there's a lot of benefits for the citizenship. I know, for example, from India, you would lose the Indian passport if you get the U.S. passport. So there's some, trade-offs there. But if you are worried at all, if you have some convictions, but you've had a green card for at least 3 years or 5 years, depending on how you got it, talk to an attorney and see if maybe you can actually get citizenship, and that will be the best protection.
Wow, that's a great advice, and thanks for giving the good example, Henry, so people can work it out accordingly. So I have a last one question. So we are talking about the green card holders. If it's same thing happened for any visa holder, say example H1B or L1 visa holders, they have some charges, not the conviction, they have some charges on the record. So does it impact their status in the USA?
No, your H1B status does not automatically get cancelled. But what people have seen is they get a letter or an email from the Department of State saying, hey, your visa has been revoked. It means that your I-94 is still valid. You are still allowed to keep working in the U.S. But when you go out, you no longer have a valid visa stamp to come back in. I had this happen last year with somebody who was on an O1 visa. They came to the U.S. and then they got an email from the Department of State saying O1 visa has been revoked. We did an investigation to try and figure out why. The only thing I could figure out is that they are from a European country that has the visa waiver, or ESTA, and a year before they were in the US on the visa waiver program as a visitor, and then their flight got moved because of a delay, and they ended up overstaying by 1 or 2 days on their I-94, right? So then when they went to get the O1 visa, there's a question on the DS-160 that asks, have you ever violated your non-immigrant status? And they answered no, because they didn't realize that they had overstayed. But they should have answered yes and said, I overstayed on my ESTA by accident because of my flight delay. That's the only thing I could find in the record. And what does that mean? It means that right now they're still in valid O1 status. They can keep working. But as soon as they go outside the U.S., they would need a new visa stamp from the consulate to come back in, and they don't want to take that risk, because what if the consulate says no? So what they're actually working on now is trying to get EB-1A and adjustment of status done so that they could keep having to go for a new visa.
Wow. Thank you so much, Henry. Yeah, you have given a lot of examples and lot of knowledge today, and we got a picture, like why Supreme Court given the decision and what the people should do if they are in this kind of situation. And thank you so much for your time, Henry. Nandri.
Oh yeah. நன்றி.